This is Bloomberg Law with June Grasso from Bloomberg Radio.
Donald Trump wasted no time in spreading the word that Fulton County prosecutor Fani Willis has been accused of misconduct in the Georgia election interference case.
Now it turns out that that case is totally compromised. In fact, they say she's in far more criminal liability than any of the people she's looking at. So I think that when you look at what happened where they pay a lawyer with absolutely no experience $700,000 who happens to be her lover or her boyfriend, and then they go on trips and vacations together, very expensive vacations together. And the reason they paid him so much because he was after me.
Trump, of course, distorted and embellished the allegations, which came from a court filing in the case. One of his co-defendants, Michael Roman, a former Trump campaign official, claims that Willis improperly hired a romantic partner to lead the RICO case and benefited financially from his appointment. The filing didn't offer any direct evidence to back up those claims, and Willis has not responded to the allegations yet. Roman is asking the judge to disqualify the entire prosecution team. My guest is Michael Moore of Moore Hall, the former U.S. Attorney for the Middle District of Georgia. Michael, what's your take on these allegations?
Well, without question, I think it's tragic for the case. And I don't mean that it means that legally that I think that the allegations raised in Mr. Roman's motion are sufficient to have the case dismissed, but it's just an unforced error on the DA's part, if they're true. And I don't know if they're true or not, but it would be hard to imagine a lawyer filing that kind of nuclear motion without having some proof in their back pocket. So whether that's a copy of some documents from the sealed divorce proceedings for Mr. Wade, or whether that's some kind of travel proof or emails or whatever they may have, the kind of things they raised in their motion, it would be hard to imagine they filed it without some backing. While I don't think, again, that it gives a legal defense, it just makes the optics terrible. And it gives the already plentiful critics of the prosecution in the case, it just gives them something else to grab hold to. And as a prosecutor, you don't want to do that.
I want to take the claims separately. Is there anything wrong with Willis having a romantic relationship, if this were the case, a romantic relationship with the special prosecutor working for her?
Well, it can be. I mean, I think there are always concerns, when you have that because of potential problems with sexual harassment and workplace problems and that type of thing. And I imagine it's somewhere in there is violative of probably some ethical provisions that she may have for the office or that the offices have long-standing. Is it illegal on its face? No. And, in their private life is their private life. They are obviously adults, and I'm assuming would be consenting adults. And so I don't know that really is the basis of the attack. It's more of a, was this appointment made, and is this prosecution itself now being used as a way to generate funds that somehow flow back to the benefit of the district attorney herself? And I think that's the basis of their motion.
Yeah, they assert that she's benefited personally from the payments he's getting. For example, that she joined him on multiple cruises and other trips he paid for. That would be improper.
Well, it certainly would be. And I think that's the concern. I mean, this, we've talked about this at some length, in the question of whether or not an elected DA should even be prosecuting a case like this. And so just if you compare the difference in, and I'm not talking about from romantic relationships, but to compare the difference in what we see in Jack Smith as special counsel versus what we're seeing in the Fulton DA's job, and that is you've got an elected official, she's moving around, making media appearances, walking on red carpets and openings and glamour things and all this, and you got Jack Smith basically who's in a cave somewhere with his minions doing his work, and he's not coming out and making public statements and putting himself out for public scrutiny. And so while the DA may argue, well, some of this I need to do as part of my job because I have to be reelected, that seems to weigh against the value of having an elected DA involved in a case like this, and it causes the case to be somewhat tainted from an optics point of view. And I think the same is true even in the appointment of staff. As we've seen, if the allegations in this motion that have been raised are accurate, then Mr. Wade has never prosecuted, at least to the knowledge of the lawyer for the motion, has not prosecuted a felony case. And so you have to be asking yourself, why would this be happening as opposed to having a career prosecutor who's well-versed and well-experienced in felony prosecutions of what I think are great import and probably one of the largest, at least, cases of notoriety right now in the country, why this would be happening. And when you start piecing all those things together, then the concerns about how much he's being paid, why is he being paid that, how was he selected, why was he selected without the approval of the commission, if that's true, why did he not sign the oath at the time before the grand jury, if that's true. All these things start to then come together. And so one mistake or one error in judgment or even one inadvertence, I think, starts to turn into really a kaleidoscope of criticism and error in the case. And while it doesn't make the case unprosecutable, it makes her job much, much harder as a prosecutor to do something and make decisions that the public can continue to have confidence in. You may not always agree with the prosecutor, but you want to be able to at least look at what they did and have confidence that somehow the system worked, that there was not some other motive out there other than to seek justice. And I worry that may be what the ramifications are if the allegations of the motion are true.
What hit me most when I was reading this is, is he qualified to be the special prosecutor handling a major RICO case, prosecuting a former president, the biggest case ever in Fulton County and
sure.
perhaps, in the country. And she had said this previously. She'd chosen him because he was a trustworthy friend and contemporary, and she thought he was thick-skinned enough to handle attacks from Trump and her own critiques. But does he have the experience to be in this position?
I will say I don't know him personally, so I'll preface my comments with that. I think it's not uncommon, and you see all over the state, again, with the district attorneys, it may not be uncommon for the district attorney themselves to not be the most experienced prosecutor in the office. I mean, sometimes they're appointed by a governor to replace somebody, and they're young staff members of the government. Same thing you see when the governor appoints somebody to the bench. Or they may be people who've just been in the office a period of time, and the district attorney resigns, and so they jump in and suddenly become the DA. But they surround themselves with other knowledgeable, qualified and experienced prosecutors. And I'm sure somehow that was what she was trying to do, or at least would be the argument she would make, that even though, if, again, the allegations are true in the motion, if Mr. Wade does not have felony prosecution experience, that he would be surrounded by people like her RICO expert and other trial lawyers that the DA's office have to come to trial. I don't think that makes the best picture for the person being called the lead trial counsel for the prosecution. I think that probably the public, knowing that, would lose some confidence in some of the decisions and tactics and strategies that will be made and publicized throughout this litigation. And it'll be blamed on his inexperience, whether it's true or not. And that is the harm that I see caused here. That those kinds of things will call into question whatever the ultimate outcome is. And it puts the judge in a unique position, too. I mean, he's sitting here now with one motion raised already about the propriety of whether or not the oath was properly done at the time. And now he's come in and he's got this issue before him. We know from before we've had the issue with the district attorney having a fundraiser for the political opponent of someone she was investigating. And one of the people alleged to have been a fake elector. She had a fundraiser for one of those political opponents at the time, and that caused some issues. In fact, his case couldn't be investigated any further. He's now the lieutenant governor here. And so it's the massing together of all of these issues that really cast some shade on the prosecution. And the question will be whether or not she stays in herself, or whether or not the best thing to do would be to say, this case is bigger than me. It's bigger than my senior counsel, Mr. Wade, and I've got to deal with these issues. And he's also got to deal with his divorce. She's been subpoenaed to testify in the divorce hearing, and she may say, I'm going to stand down and let the governor appoint somebody else to come and finish the case. I'll bet you about 99.999% she wouldn't do that of her own volition, but that to me would be the path that's probably called for at this point.
I can't take that bet because I agree with you. Coming up next on the Bloomberg Law Show, what about those legal fees Wade was paid? About $654,000 over 2 years. I'm June Grasso, and you're listening to Bloomberg. I've been talking to Michael Moore, the former U.S. Attorney for the Middle District of Georgia, about the allegations that Fulton County Prosecutor Fani Willis improperly hired her romantic partner to be the special prosecutor leading the RICO case against Donald Trump and 14 others. He was paid about $654,000 in legal fees in 2022 and 2023. I mean, is that commensurate with what a person would get?
No, that's not commensurate at all. I mean, the district attorney probably makes, with county supplements and that kind of thing, probably a little less than $200,000 a year herself. An average assistant district attorney would probably make around $120,000 to $160,000 a year. Somebody who's had some experience, a good bit of experience. And so our appellate judges, I think the Supreme Court now is making maybe $200,000 or a little over $200,000 a year. Federal judges make a little over $200,000 a year. When I was a United States attorney, the pay for the United States attorneys was capped at about $154,000 a year. And so this has been a windfall to him in income. And I think that, again, is part of the optics problem that she has, is that it's so out of the norm for what's being paid by some of the highest legal officials and judicial officials in the state that it immediately catches your attention.
The motion is to disqualify the whole prosecution team and to dismiss the indictment. It seems like dismissing the indictment is way out of line, but
I think so, yeah. I think it's unlikely that the indictment would be dismissed. I mean, the grand jury met. I think there may be other reasons, and there could be other motions raised about the sufficiency of the indictment or the legalities of certain allegations set forth. And I mean, those are questions that really go more to whether or not an indictment should be dismissed. I think that the allegation of the personal relationship would have no bearing on the issue of the dismissal of the indictment. I think it could, and I think the judge will be thinking about this as well. It could result in a suggestion that she recuse herself and Mr. Wade from the case. I don't know how that would be received. Again, I mean, if the reporting is correct and Ms. Willis has now been subpoenaed to testify in Mr. Wade's divorce proceeding, what comes out of that, what part of that record may be made public, those kinds of things, that may further, inflame the situation that we're in now. The case, in the judge's mind, I think, is probably one to be decided by a jury and not encumbered by the personal baggage that's been added to it. And I don't think he would let the defense make much hay about the personal relationship and that kind of thing in front of a jury. I do think there's some things that have come out that may very well get into evidence before the jury that have come out as a result of this motion, and one of those being whether or not, in fact, Mr. Wade was in communication on at least 2 occasions with Democratic officials in the Biden White House. If that's the case, if those 2 8-hour entries are accurate, I think that could lead to some questioning of whether or not the case is politically motivated, whether or not it's being controlled by Democrats and the political opponent of the current defendant. I think that could very well find its way at some point into a case under certain circumstances, and if the door is opened, that's always a fear.
That certainly would play into Trump's whole
right. Again, that's what I mean. This kind of thing has given now Trump's supporters that much more to argue about. Apparently, there were some entries on the time record showing at least 2 meetings, and I think Mr. Wade billed, and that's how they came about, is looking at billing statements. They show at least 2 entries where he was talking with people in the Biden White House. There'll be some people who question and say, well, that's legitimate. He's trying to get information or get a waiver of executive privilege and that type of thing. You can make that argument, but for people who may have already been inclined to not accept the validity of the prosecution and the validity of the allegations of the case itself, it certainly stokes the fire that there is, something afoot, and certainly at least there's smoke somewhere, and they're going to argue then that there's certainly fire and that the Biden White House is having some communication and control over the case. The DA has been very coy about her comments and discussions with the Congress and whether or not there has been any sharing of information with the committee, January 6th committee, and all these things. And so this now, depending on if there have been any representations made in court about what the prosecution's file consists of, what information should be turned over to a defendant during the regular course of discovery. This may open the door to some further review and maybe even an in-camera review by the court.
Turning to another issue, Trump is seeking to have the case thrown out by arguing he's protected from prosecution under presidential immunity. So that's the same claim he's making in the federal case in D.C. Will the decision of the D.C. Circuit Court of Appeals have any impact in Georgia?
It will. These issues of constitutional questions and presidential immunity questions would ultimately find their way to the Supreme Court, I think. And you saw this in the case already where we had the issue about should the case be transferred. And, it was heard in federal court, and the 11th Circuit Court of Appeals made a quick ruling, and I think Mr. Meadows is still appealing some of that. But that obviously affects the state case. The same thing here. If the court rules that his conduct is protected by presidential immunity, then I think that pretty much shuts down most of the Trump case. Part of the issue with the indictment that is pending in Fulton County is it focuses almost exclusively on presidential conduct, or Mr. Trump's conduct, rather, while he was president. I guess the question of whether it's presidential conduct will be decided by a court, but certainly while he was the sitting president of the United States. And so the question for the appellate court will now be, how do we decide and who gets to decide whether or not specific acts that occurred by a president were inside or outside his or her presidential duties? So there was an interesting back and forth with one of the judges in the D.C. Circuit in this case, and the question was asked something to the effect of, well, could a sitting president order SEAL Team 6 to kill his political opponent? I think most people would say absolutely not. That's not ridiculous, but absurd a little bit in a way. Well, the question might also be asked, could a president order SEAL Team 6 to kill his political opponent who happened to be in possession of and threatened to detonate a nuclear bomb if he wasn't given the White House? That's a different question. So these are not just simple black and white questions, but these are gray issues. And that, I think, at the end of the day, will be the issue the Supreme Court has to weigh in on and will affect Georgia in the case. Who decides whether or not the specific act set forth in the indictment was within the bounds of the presidency and presidential authority, and who decides if it's not, and how do we define that conduct? And so these are huge issues and big questions that are certainly not the first of their kind, because we saw a little bit of this in the Nixon case, but when it comes to the allegations in this indictment and the number of criminal cases pending in the various jurisdictions, the number of jurisdictions where those cases are pending, it's certainly a first. If you would, the Supreme Court basically has a lot of loose threads being thrust at it, and it's got to figure out how to tie all those things up into a knot so that the decision leaves the courts below clarity on how to move forward.
If the court takes the case, it'll be another issue related to the 2024 presidential campaign that the court decides. Thanks so much, Michael. That's Michael Moore, a partner at Moore Hall and the former U.S. Attorney for the Middle District of Georgia. It's a trial in which control of Donald Trump's business empire is at stake, not to mention the $370 million in damages the New York Attorney General is seeking. Yet the Thursday finale of New York's civil fraud trial against Trump was engineered to provide the former president and Republican frontrunner with the latest opportunity to steal the spotlight. As lawyers for the New York AG, Letitia James delivered closing arguments in the courtroom where the trial had played out for almost 11 weeks, Trump's seat at the defense table was empty. He'd left to hold a press conference in the marble lobby of his 40 Wall Street skyscraper with a backdrop of carefully arranged American flags. His rhetoric was familiar and all about grievance.
And so it's all a conspiracy to try and get Biden, who can't put two sentences together, trying to get him into office. So I just want to let you know that we have our best poll numbers, we have the best everything, despite this, and maybe because of this, because the people of the United States, all of those people back there, but the people of the United States really get it. They get it better than anybody else.
In addition to the New York trial, Trump is facing 5 other trials, 4 criminal and 1 civil. And he blamed all of them on his political opponent.
Well, see, my legal issues, every one of them, everyone, civil and the criminal ones, are all set up by Joe Biden, crooked Joe Biden. This is something that's never happened in this country. Even when you look at this is all about Biden and her meeting. So even the civil ones, this is civil, they're set up by Biden. Every single, just about, case that I'm involved in is set up by Biden. They're doing it for election interference.
Letitia James responded to Trump's attacks after the closing arguments were finished.
This case has never been about politics or personal vendetta or about name-calling. This case is about the facts and the law. And Mr. Donald Trump violated the law.
Joining me is Bloomberg legal reporter Patricia Hurtado, who was in the courtroom today. Patty, I thought it had been decided that Trump was not going to speak at the closing arguments. Yet he did speak. What happened?
Email exchanges began last week between the court, the AG, and Trump's lawyers, suggesting that Trump wanted to speak. And the emails that were filed show that the judge was basically telling Trump's lawyers that, number one, the AG's office is flipping out, that there's no precedent for a defendant to help deliver their own closing arguments. That's not the forum, and that's not proper. And then the judge was saying, is your client willing to follow the rules, which are no political speeches, but basically stick to the facts and the evidence that you're arguing and not make political speeches. And the judge gave him multiple deadlines. And at one point, the judge was basically saying, you've got a drop dead deadline. You have to tell me if he's going to speak on Thursday. And then Trump's lawyer says that Melania's mother passed away, so he'd like to postpone everything till the 29th of January. And the judge is like, no, you can't. And then he's basically saying, it's very unfair, Your Honor, to do this, not allowing President Trump, who's been wrongfully demeaned and belittled by an out-of-control, politically motivated attorney general, to speak about the things that must be spoken about. So it seemed like the matter was, the judge said, I won't debate this again, take it or leave it, now or never. You have until noon, 7 minutes from now. I will not grant any further extensions. And that last sentence, I will not grant any further extensions, was all in caps. And then the judge messages back, hey, it's 12:12 now. I never heard from you. So I assume that your client will not agree to the reasonable, lawful limits that I have imposed as a precondition to giving a closing statement above and beyond those given by his lawyers. Because, we all know the rules. A party's not supposed to be speaking in court. So basically, he had to abide by the rules, the judge said, as we know, that the judge gave him, you can't just let your client make a speech. So today, Trump's lawyers, 3 of them, gave closing statements, and he gave them a time limit, and they finished. And then Trump's one of his main lawyers, Chris Kise, turns to the judge and says, I know you said that my client couldn't speak, but now could he speak? He'd like to speak. And the judge is like, well, will he abide by the rules? I set, the ground rules. Will he promise to do that? Mr. Trump, do you promise to do that? And then Trump didn't even answer him, just launches into, yeah, I'll abide by the ground rules. And he just starts speechifying. And it's going on and on and on. And he spoke for about 6 minutes in a diatribe against the AG, against everyone that was unfair to him, about the judge.
And we should point out that the judge is the one that's going to be deciding this case. There is no jury, yet he's been attacking the judge.
He accused the judge of not paying any attention. He said the judge never listens for more than a minute anyway. And the judge had already put limits on everybody. So it wasn't like Trump was going to be allowed to speak extemporaneously for a half hour like he probably wanted to. And so he said things like, they heard triplets and they just multiplied it by 3. Things like that happen. It's a very small number. He's talking about the triplets was tripled, right? We have a situation where I'm an innocent man. Legal scholars find this case disgraceful. This is the first time they've used this statute. It's the first time it's been ever used. This is not consumer fraud. It's a fraud on me. They did this with Exxon, and look what happened. Exxon left for Texas, alleging that the AG's office sued Exxon, and they up and left for Texas. But the AG office later said the AG didn't sue Exxon before they left. that was after, and that they left for Texas in 1989, way before the lawsuit was ever filed.
It sounds like he repeated the same claims of political bias and election interference that we've heard over and over again.
And so he says, how many taxes I paid? It's close to $300 million. But they don't want me here. They don't want Trump here. It's because I ran for office. It's because of the person here who hates me. Without these days and months and years and millions of pages, they found nothing. And for what? I borrowed money from the bank, much smaller than $370 million. And then that's when the judge interrupted and he goes, just one more minute. And then he goes, you can't listen for more than 1 minute. Retorts back to the judge. They should pay me for what I've gone through. And then the judge says, okay, thank you very much. Mr. Kais, can you please control your client? And then he goes, Mr. Kais, this should have been done differently. We now have to leave this, because they had to leave the courtroom because everybody was on their lunch hour and Trump was still fomenting.
I know that Trump's lawyers argued the political angle, which we've heard over and over and over again. What else did they argue?
It's a whole witch hunt. It's a thing improper. If anyone made any mistakes, it's all Mazar's fault. It was always mistakes were made, but they're not important and material. No one was harmed. The banks weren't harmed, stuff like that. You know, it's been the same exact thing this whole time.
Did the AG have anyone on the stand who said they were harmed by this?
Well, they did have a Deutsche Bank banker who said that the lending terms would have not been this way had they known the truth about the true value of segments, his true net worth. And then they had Zurich Insurer and a Tokyo Marine Insurer that the terms of lending would have been much different had they known the true net worth as opposed to what was stated in the inflated statements of financial condition for Trump.
This is only about, 4 or 6 counts left?
Yes. The judge has already found that the statements of financial condition were fraudulent. So that's pretrial ruling. He found them liable. So now they want remedies. They want disgorgement of $370 million. They also are sort of suggesting that they want Trump to be barred from making any more new loans for the next 5 years, no new real estate transactions. Basically, Trump's lawyers were arguing today that would be a death penalty for the company, and also it was not warranted at all.
We know the judge has already ruled against him, and we know that Trump has done nothing but antagonize the judge. Do you have any inclination from what the judge said?
Well, there were a couple of points of time today where the judge was, whether he's playing devil's advocate or was actually voicing specific concerns about the paucity of evidence in certain claims. There were certainly questions about whether the sons had knowingly intended to defraud. The AG said there was plenty there. You can't visit the sins of the father on the children, basically kind of argument. The judge seemed to be a little bit, questioning that. They also, the judge interrupted at one point. The AG had made the comparison that Martin Shkreli was banned from doing business in the pharmaceutical industry by a federal judge, and it's the pharma bro after being convicted, and that they were basically saying that this is similar. And then the judge goes, do you think this case is as bad as Madoff? How would you compare it to the Madoff Ponzi scheme, which is kind of wild because it has nothing to do with a Ponzi scheme?
It is wild.
The AG's office had to say, it's much smaller, it's much different, a much smaller kind of case. But that said, what it says, he approved of this fraud, and if you're rich enough, you can get away with it.
So while the trial was still going on, while the AG's office was making closing argument, Trump held a press conference downtown at his 40 Wall Street building.
A tactical move to steer the press's attention away from what was happening in a state case like this, civil fraud. The defendant goes first with closing statement, and then the plaintiff, which is the AG, goes second. So all morning long, Trump was a very quiet, very attentive student listening to every word, rapt attention to what three lawyers were saying. And no grumbling or mumbling from him. And then he gave his speech, and then he left for lunch. And then he went down to 40 Wall Street to have a press conference. And it was announced earlier in the day as a campaign stop, and he used it to trash the case again.
Why did the AG raise the amount of money she wants the judge to award?
It's complicated, but essentially there's been a series of transactions that have happened. For example, sales of like a golf course in northern Manhattan, so a New York City golf course, that Ferry Point, that he made a profit on. So these are kinds of extra profits that Trump borrowed money, got this borrowed money under these terms, according to fraudulent terms, according to the AG's case. And therefore, since he's made profits by selling these properties recently, he should have to cough up extra money now because he's made extra gains.
And the judge said he'll aim to deliver a verdict before January 31st. Look for another press conference then, or probably 2 press conferences. Thanks so much, Patty. That's Patricia Hurtado, Bloomberg legal reporter. And in less than a week, the next trial for Trump will begin, the defamation suit by E. Jean Carroll. It will start one day after the Iowa caucuses. Trump said he'll attend the trial. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.